Good morning, everyone, and welcome to today's webinar. For those of you who have just logged on, we have already completed a sound test, and thank you very much to everyone who helped out with that. If you do have any trouble hearing us or seeing the slides, please just type into the chat box and one of my colleagues will get back to you. So firstly, I just want to introduce ourselves. My name is Jennifer Patton and I'm the HR consultant for Bright Contracts here at Thesaurus Software. And joining me today is Laura Murphy, who is the Chief Human Resources Officer at Thesaurus Software and an additional point of contact for Bright Contracts. So just to note, this webinar is being recorded and all attendees will receive an email later today with a link to the recording. So it's no problem at all if you do need to pop off at any stage. If you do have any questions, you can type them into the questions box on your control panel at the side of the screen, and we will try to get through as many questions as possible at the end of the webinar. Also, in the follow-up email, there will be a copy of today's presentation slides that we are using today. So let's get started. So first up on our agenda for today, we'll be looking at the Maternity Protection Acts 1994 and 2004, and then the Adoptive Leave Acts 1995 and 2005. Then we'll move on to the Paternity Leave and Benefit Act 2016 and the Parents Leave and Benefit Act 2019. And then finally, towards the end of the webinar, we will be looking at the Parental Leave Acts 1998 to 2019, and then where all of this leave falls into our Bright Contracts software. As I previously mentioned, at the end of the webinar, we will have a Q&A section where we'll answer any questions that you may have. So again, just type them into the chat box and we will try to get through as many as possible at the end of the webinar.
Perfect. So thanks very much for the introduction, Jennifer, and good morning, everybody. Laura here. So yeah, as Jennifer said, let's get started with the Maternity Protection Acts 1994 and 2004. So the main provision of these acts is to provide for the 26 weeks maternity leave with protection of employment for female employees. And as I'm sure many of you are familiar, the act also entitles employees to a further 16 weeks, which is known as additional maternity leave. There are also a number of other provisions in the Act. So firstly, we have leave on the grounds of health and safety, and this falls also under the Safety, Health and Welfare at Work Act. But we'll look at that in a little bit more detail shortly. And then the Act also allows for leave of an employed father from his employment in the extremely unfortunate situation where a mother might die, or the death of a mother during her maternity leave. Who does the Act cover? So the Act covers all female employees from their first day of employment. So you don't have to have any service requirement to be entitled to maternity leave. And that would include all employees, including contract workers, apprentices, agency temps, or anybody working for as a civil servant or with a local authority. So it's quite broad and it covers everybody really.
And we just wanted to cover as well premature birth. So since the 1st of October 2017, female employees are entitled to extend their maternity leave beyond the 26 weeks where their baby is born more than 2 weeks before the expected week of confinement. Essentially what that means is the due date that the child is due to be born. So the amount of extended leave will be equivalent to the duration of the premature birth period. And the premature birth period means a period which commences on the actual date the child was due to be born and expires 2 weeks before the end of the expected week of birth. So to put that a bit more simply, if a baby was born 2 weeks early, then the employee will be entitled to the 26 weeks consecutive maternity leave plus the extension to her maternity leave by the premature birth period. So that would bring her entire period to 28 weeks. So we just thought that we'd approach this next section as kind of like a Q&A, and these are some of the common questions that we get in relation to maternity leave. So first up, we have, when must an employee commence maternity leave? So an employee is required to take what is called pre-confinement maternity leave, which is a minimum of 2 weeks and a maximum of 22 weeks before the end of the week in which the baby is due. So this means that the employee must have a minimum of 4 weeks maternity leave remaining after the birth of the baby. Next, then, how must an employee notify their employer of their intention to take maternity leave? So, the employee must give their employer at least 4 weeks' notice before the commencement of maternity leave, and they must state the date on which the leave is due to commence, but also produce a medical certificate confirming the pregnancy and the expected week of birth. So when does additional maternity leave commence? So it must commence immediately after the 26 weeks maternity leave or any extended leave due to a premature birth. And does an employee accrue annual leave whilst on maternity leave? So to put it very simply, yes, they do. The employee is still treated as being in employment while they're on maternity leave or additional maternity leave. So this means that they continue to accrue annual leave, but they're also entitled to leave for any public holidays that occur during their maternity leave or additional maternity leave. So it is important to note that they are allowed to automatically carry over this leave into the next year as well. So that's something important to remember. And then lastly, what are an employee's rights on fixed term contracts? So women who are employed under fixed term contracts may not be entitled to the full period of maternity leave or additional maternity leave if their contract ends while they're still on their leave. Their leave will also end on that same day. But the expiry of the employee's contract of employment during their maternity leave, it doesn't affect their entitlement to maternity benefit.
Just to come in there, Jennifer, talking about when an employee goes on maternity leave, I think it's really important to also note, it might not be something that's covered in the Act, but it's something that employers should really keep at the forefront of their mind when somebody's going away, is to keep in contact with the employee. It's really important to have some form of contact. Obviously, you don't want to over bombard them with information and company information, but you don't want to totally leave them out of the loop. So it's about maybe before they go on maternity leave or a leave to decide, well, what's suitable, how best do we contact you. So if there are changes in management, changes to their team, and any kind of company announcements or memos, it'd be just well advised to send that to the employee who is on leave as well. And it just helps the employment relationship and makes it much easier then as well for the employee on her return. And then lastly as well, don't assume that the employee on maternity leave cannot attend social events. That might be something that might be very welcome for both parties. So again, if there's anything happening, restrictions permitting, I guess. Yeah, remember your employee on maternity leave. Just then, a few other things to consider, and I mentioned earlier health and safety leave, so I just want to take a little look at that now as well. So health and safety leave can be granted to a pregnant woman or to a woman who has given birth within the previous 14 weeks, or a woman who is breastfeeding up to 26 weeks after the birth, so up to 6 months after the birth. In terms of what you need to do to decide should health and safety leave even be a consideration, really a risk assessment is going to be key. So where there is an activity at your work or in the employee's job that is likely to expose her to particular hazardous working conditions and expose her to a risk, you should carry out a risk assessment to assess what is the level of danger, and your risk assessment then will help you establish, can you put any measures in place to remove that risk from the employee. If you can't do that, then you'll need to look at, can you offer the individual some alternative work. And then really as a last resort, you're going to be looking at, okay, well, there is a major risk here to the pregnant employee. I can't remove the risk. I can't put her somewhere else. I will grant her health and safety leave. In my experience, I haven't come across it too often. As I said, it's always a last resort, but an important last resort nonetheless. There is some situations then as well where you may need to provide an employee with a health and safety certificate, and I'll explain that next. I suppose in terms of whether health and safety leave is paid, just if we move on to the next slide there, Jennifer, sorry. An employee who is granted health and safety leave by their employer must be paid their usual wages for the first 21 days. So for the first 3 weeks, they should receive their basic pay. And you can exclude any overtime. But then from 22 days onwards, if they're not falling into the actual maternity benefit side of things. So from 22 days onwards, they may be entitled to health and safety benefit from the DSP. And in this situation, then you may need, or you may be requested to provide a certificate to the individual.
Thanks, Laura. So this brings us on to then maternity benefit and the employer. So employees apply for maternity benefit using what is called an MB1 form, and the employer completes what is called an MB2 form. And the MB2 form, it just confirms the start date and end date of the employee's maternity leave and the employee's expected due date. And both of these forms, they are available on gov.ie, but we're actually going to link them for you in the follow-up email as well. Now, just an important thing that we thought would be good to mention is that while there's no set period of retention on the data on maternity leave, claims can be made within 6 months of employers being informed of an issue, which is giving rise to a dispute, but it can be extended to 12 months in exceptional circumstances. So just an important thing for employers to be aware in relation to retaining records. Then also, when an employee is returning to work from their protected leave, they are entitled to return to work with the same employer, the same job, under the same contract as they had before, but also the terms and conditions that are as good as those as they had before. And we just really wanted to highlight the importance of this. So on the next slide, we're actually going to go through a recent case law, which just reinforces the importance of following proper procedure when it comes to pregnancy-related leave, and the potential employment law cases that need to be avoided as well. So this case here that we are going to be speaking about is Miss Kelly against G4S Secure Solutions. So Miss Kelly had been employed by this company and worked on a site in Swords, but after her return from maternity leave, her employer had instructed her not to return to the Swords site because the employer's client had actually requested that she don't return to the site. So Miss Kelly was offered a fixed term contract of 3 months, which was later extended to 6 months. But this was in the employer's head office in Ballymount, which was actually very problematic for the employee because it involved a 4-hour round trip to work, but no other offers were made to her as an alternative. So in April 2018, the employer actually stopped paying Miss Kelly, and she requested her P45 in June of that year. So the decision that the court came to in relation to this case was that they found that prior to Miss Kelly's maternity leave, she was working 30 minutes from home, she was on a permanent contract, but after her maternity leave, she was expected to travel 4 hours each day and work on a fixed term contract. So based on those facts, the court actually didn't accept that the terms of this contract were not less favourable than her previous contract. So the court also noted that no other option or alternative was given to Miss Kelly at any stage of the process. So therefore, they actually awarded Miss Kelly the maximum amount, which was €51,168. Now, this is obviously a very tough amount for any business to swallow, and it's not a position that any company would like to see themselves in. So that case is just to reinforce the importance of following proper procedure and also making sure that you retain your records if something like this should arise in your business as well.
Yeah, a really interesting case, and interesting to see how easily it can all go wrong and how high that fine can actually be. So a good one to just be aware of. I suppose on the back of that case, we wanted to get a little bit of audience participation, I think, and we wanted to discuss what protections are afforded to employees while on leave, in relation particularly to protecting them from unfair dismissal. So we have, just to make sure everybody's with us today, we have a couple of little polls that we want to go through. To say first, the answers are entirely anonymous. We're not calling on anybody, but we'd love to get, just to make it a little bit fun, I suppose. So the first question being, when is it unfair to dismiss a pregnant employee? So we'll give you a few moments there, and Jennifer, you can see the results coming in, so you just let me know when I need to go ahead with the answer.
Everyone's very quick, so everyone is actually very correct. So Laura is actually going to go through the answer there now, but everyone is spot on. So we're off to a great start.
Well done, everybody's well alert this morning. Well done, everybody. So it is unfair to dismiss an employee on all of the grounds. Oh, well done, 100% for all of the ones. That's excellent. We'll go on. There's no point to dwell on that one, so everybody knows. The second one: are employees protected against dismissal while on pregnancy-related leave?
I'm just going to give it a few more minutes there. We have some more answers coming in. But everyone's on top of their game this morning. Everyone's spot on, which is great to see.
Perfect. So yes, as you all seem to know, they are protected from dismissal when on maternity leave, but also protected from dismissal when they are attending an antenatal class, when they are breastfeeding, and when they're on health and safety leave that we've already discussed. So yeah, well done. So ready for me to go on to poll number 3. This is the final one for the moment. Can the employer decide the terms of the employee's maternity rights and entitlements?
We have a lot of answers coming through here. I'll just give it a few more minutes, Laura, just for a few more answers are all coming in there. We always find that this question is a good one. It's always a bit of a mix sometimes. Okay, perfect. We have a lot of answers coming in there, and Laura's going to go ahead with the answer. But again, everyone's spot on.
Oh, you've made these questions too easy, Jennifer.
I know, I need to make them tougher.
The employer is not allowed to amend the terms and conditions, and that's regardless of whether somebody is on more favourable terms than the statutory minimum. So no, you shouldn't be amending terms when somebody's on maternity leave, with the exception of pay, of course.
So that's all great. Thank you so much, everyone, for taking part in our polls. And this brings us on to then Adoptive Leave Acts 1995 and 2005. So the Adoptive Leave Act originally covered all adopting mothers or sole male adopters who are in employment. But positively, there was a revision of the Act just this year, which actually expanded adoptive leave to a parent who adopts alone or to one parent of any couple that jointly adopts, and they will choose which of them will avail of adoptive leave. So it's great to see some positive change in these acts. And under this Act, an employee is entitled to a minimum of 24 consecutive weeks adoptive leave and an optional 16 weeks additional adoptive leave. Now, an adoptive parent must give their employer at least 4 weeks written notice of the expected date of placement of the child and confirm this as soon as they possibly can. And a certificate of placement, which is generally taken from the Adoption Authority of Ireland or the HSE, this must be given to the employer no later than 4 weeks after the date of placement. So that's an important thing that needs to be there for record retention as well. And adopting parents are entitled to time off during working hours without loss of pay to attend preparation classes and pre-adoption meetings with social workers or health board officials. And this is all required during their pre-adoption process. So it's really important to note there that they are entitled to this time off. And same as maternity leave, there is no set period of retention in relation to the records for adoptive leave. But again, claims can be made within 6 months or extended to 12 months in exceptional circumstances. So again, it's just really important to keep on top of your record keeping here.
Perfect. So I think that brings us then on to paternity leave and the Paternity Leave and Benefit Act of 2016. So it was brought in 2016, giving 2 consecutive weeks paternity leave with protection of employment for a relevant parent in respect of a child born or adopted after the 1st of September 2016. And there is also a provision which allows paternity leave to be transferred to the surviving partner or surviving parent in the case of a death, unfortunately. When I say relevant parent here, I mean the father of a child or the partner of the mother. And it's 2 weeks consecutive. And in terms of who is covered by the Act, again, all relevant parents are from their first day of employment, so there's no service requirement. And again, that would include your agency temps and your civil servants. In terms of when parents can take paternity leave, it can be taken at any time commencing from the date of the birth of the child or placement for adoption, but no later than 26 weeks after the birth or placement. So really in that first 6 months of the birth or placement, paternity leave should be taken. And then in terms of once PRSI eligibility criteria are met, there is payment there is a paternity benefit payment.
Great, and I just thought that I'd come in there, Laura. So we actually came across some interesting articles which we thought we'd share some facts with you all. That actually, surprisingly, almost half of fathers entitled to paternity benefit don't actually avail of it. And the level of uptake, it varies dramatically depending on the sector and the size of the company the person works in. But also, while paid and unpaid leave for new fathers has increased and expanded in recent years, the uptake actually remains quite low, with less than half of fathers, so about 45%, of fathers who are entitled to paternity benefit, they didn't actually take it up in 2018. So we just thought that that was a bit of an interesting fact that we would share with you all there. But this also brought us on to then, we were on the Central Statistics Office website, and they actually have this PDF of an employment analysis of maternity and paternity benefits. Now, they haven't updated it past 2019 at present, but we still thought that the figures presented for 2016 to 2019 were definitely still interesting and worth looking at. So as you can see here, in 2019, paternity leave was paid to 3.1 men per 100 employees, which is a slight increase on the 2018 rate, which was just at 2.9. But it is still well below the rate of maternity benefit, which was paid to 5.3 per 100 employees in 2019. So there's definitely a lot more uptake of the maternity benefit than the paternity, which I don't think is as unexpected. And also, interestingly, it has the sectors then with the highest paternity and maternity benefit rates. So this is the public administration and defence sector. And the accommodation and food service actually has the lowest maternity and paternity benefit rate. So they're just some interesting tidbits of information we thought that we'd share. But next, we're going to go back to a little bit of interaction. So we're going to go back to some polls.
Yes, back to the polls. There were some really interesting stats, Jennifer. So first question this time, how much notice must the employee give of their intention to take paternity leave? So same as before, I'll just give you a couple of seconds for the answers to come through. Let me know when, Jennifer.
Yeah, there's a bit of a mix here. I've probably made this one a little bit harder. So we have a bit of a mix of answers here. But I think you're okay to go on ahead there, Laura.
Okay, so to exercise an employee's right to paternity leave, they must give their employer 4 weeks written notice of their intention to take the leave. And that's starting the date the leave is due to commence and the day, and also include the day of their return. Just to note also, in the case of multiple births or multiple children for adoption, the relevant parent is still only entitled to a 2-week period. It doesn't double. Okay, so second question then. How long must employers keep records of paternity leave? Am I still on the right question? Oh, sorry, I've skipped ahead.
Oh, no, that's okay.
Is the employee still entitled to benefits while on leave?
I'm just going to launch this one here. It's great to see some interaction with this. So thank you very much to everyone who's taken time to answer the polls, and you're all on top of your game this morning. So again, we have all the right answers coming through there. So Laura, you can go on ahead.
Perfect. So an employee's employment rights, statutory, contractual or otherwise, are protected during their 2-week paternity leave, except, as we said with maternity earlier, with the right to their normal pay. Any benefits that the employee would be entitled to, such as their leave, they're not affected by taking the paternity leave. And is it then the one last question in terms of the records? Yeah. So how long must the employee keep their paternity leave records for? I think you've given them the answer there, Jennifer.
I said I'd give the answer for this one because I think in relation to maternity and adoptive, when there's not really any guidelines around that, I think this one's a bit of a tricky one. So I said that I'd give you all the answer here. So the employer is actually required to keep a record of paternity leave taken by their employees, and their records must specify the period of employment of each employee, but also the dates and times the paternity leave was taken. Now, these records must be maintained for a period of 8 years after paternity leave, so a significant amount of time. And failure to keep these records can mean that the employer is liable to a hefty fine, which can be up to but not exceeding €4,000. So that's obviously quite a hefty fine for any company to get. So again, just make sure that you keep sufficient records in relation to paternity leave.
And it's so easily done to keep your records, rather than put yourself at risk of such a fine. It's so easy to do, just to keep your written records of the leave.
Exactly. And this brings us nicely on to our next topic, which is the Parents Leave and Benefit Act, which I know sometimes can be confused with the Parental Leave Act. Even we get confused. So we will be going through the differentiation between the two, and it should hopefully become a bit more clearer in the slight differences between those there. So we'll touch on Parents Leave first and then move on to Parental Leave. So, the Parents Leave Act provides for 5 weeks parents' leave with protection of employment for a relevant parent in respect of a child born or adopted on or after the 1st of November 2019. And the purpose of this act is to enable the relevant parent to provide or assist in the provision of care to the child. Now, this leave can be taken within 24 months, so up to the child's second birthday, or within 2 years following the adoption of a child. And parents can take 5 weeks together, or they can take separate weeks of leave. It's entirely up to them. Whilst Parents Leave is available to both parents, it isn't possible for parents to transfer the leave to the other parent. So that's an important thing to note there as well. And while on parents' leave, an employee will normally be entitled to statutory parents' leave, but this is depending on how they meet certain PRSI eligibility criteria. And employees who are wishing to take parents' leave, they need to notify their employer in writing, giving them at least 6 weeks' notice of their intention to take the leave. And when giving this notice, they should state the expected start date of the leave, how they intend to take the leave, so whether it's 5 weeks together or separate weeks of leave. And the employee may also be required to provide a medical certificate confirming the pregnancy and the expected date of birth, or possibly a copy of the birth or adoption certificate for the child.
And just to move on there, Jennifer, and something important I feel to note is that employers don't always have to approve the request, or certainly there is an allowance that an employer may postpone a request for parents' leave, and you can postpone a request for the leave by up to 12 weeks, where you feel that by granting the leave that would actually have an adverse effect on your business. Perhaps it's coming up to Christmas busy period, and you just can't afford to have somebody take the 5 weeks per parents' leave. But before you do postpone any request, you have to consult with the employee. And once you've made that decision and you've had the conversation with the employee, you will also have to put it in writing that you have postponed their request for parents' leave, and that should be done 4 weeks in advance of their intended start date. And the legislation particularly sets out what you must include in your letter of postponement. So you need to put in writing the grounds for which you are postponing the request for parents' leave. And just to note, you may only postpone a request once, on one occasion. And then finally, just on parents' leave, like all the other family leaves, employees' rights are preserved and annual leave will continue to accrue during this period. Then I just want to touch on, Jennifer, moving on to the relationship between parents' leave and maternity leave. So going back to our female employees, I suppose, those taking maternity leave. And now we come to maternity leave and then additional maternity leave. So if you have an employee who wishes to take some or all of their 16 weeks unpaid maternity leave, that period must be taken directly after their paid maternity leave, directly after their 26 weeks paid maternity leave. Now, they don't have to take the full 16 weeks unpaid, but if they do take some of it, it has to be taken straight after their maternity leave. They can however move directly onto parents' leave, the parents' benefit of 5 weeks, but if they do that, it will effectively end their maternity leave. So they couldn't go from their 26 weeks paid maternity, then take their 5 weeks parents' leave, and then take their 16 weeks additional unpaid. It wouldn't work like that. You would have to take your paid maternity, then your unpaid, and then have the option to take your 5 weeks paid at the end or another time within the first two years of the child's birth or adoption. And hopefully that makes sense.
Thanks, Laura. So then lastly, we're moving on to the Parental Leave Acts 1998 to 2019. So parental leave provides for unpaid leave from work for both parents. So that's the differentiation there between parents' leave and parental. It's available to both parents to look after their young children. So parents, adoptive parents, and those acting as a parent to a child, they're entitled to 26 weeks unpaid parental leave. And this leave must be taken before the child's 12th birthday, or in the case of a child with a disability, before their 16th birthday. So in order to qualify for the leave, individuals should have completed 1 year's continuous service on the date the parental leave is due to commence. But if an employee's child is very near the age threshold and they've been working with their employer for more than 3 months, but less than 1 year, they may take pro rata parental leave.
Yeah, just an interesting point ever come in there, Jennifer. There was an article in one of the papers recently, and it was saying, surprisingly, nearly 50% of fathers do not take parental leave at all, which is actually 50% do, which is probably higher than I would have thought as well, but an interesting stat nonetheless.
That's great. Thanks, Laura. And this leads us on to how can parental leave be taken. So parental leave can be taken in 3 ways. So either as one continuous period, as 2 separate periods of a minimum of 6 continuous weeks, or at the company's discretion. So the employee can agree upon this with the company, if it's going to interfere with business needs, and they can come together and work an arrangement there. But when the employee returns to work after taking parental leave, it's important to note that they are entitled to ask for a change in their work pattern or working hours for a set period. So that's just an important piece of information to note there. And just again, going back to record keeping, so in relation to this leave, the employer is required to keep a record for a period of 12 years. So again, a substantial amount of time. And these records must specify the period of employment for each employee, as well as the dates and times of the leave taken. Now, the fine for this is slightly less than parent leave, and it is up to €2,500. But basically, as Laura had said before, it's just really important to keep on top of your record keeping for all types of leave, just in the event that a case could be taken. You don't want to be caught off guard or trying to dig through old boxes for files. So just making sure that you really keep all of those records and that they're always in reach and attainable.
Absolutely. So again, similar point to what we spoke about on parents' leave. What if it doesn't suit you to approve the parental leave at a particular time? Well, there is discretion for management, and as an employer, you do have the ability to again postpone a request for parental leave for up to 6 months if you are confident that, again, in approving the leave, it would have an adverse impact on your business. Also, another point to make is that if the parent becomes ill while they are on parental leave and they're unable to care for the child, then the leave can be suspended for the duration of the illness, and the employee would be considered as if they were on sick leave. Employees are not entitled to be paid while on parental leave, so it's an unpaid leave, and there is also no entitlement to any social welfare payments that we've spoken about with parents' leave or maternity benefit and paternity benefit. Taking parental leave does not, whilst there's no pay, there is no impact on your employment rights. So all employment rights otherwise are maintained, including annual leave and public holiday entitlement. They're all preserved whilst on parental leave. So the other thing then that we wanted to just touch on, because I know when we're dealing with parents, and we're probably very much talking about the family-friendly leave at the time of the birth or new adoption, but something that we certainly come across from time to time is then those parents with maybe older children who are sick or whatnot, and what's the role of force majeure there? So force majeure allows employees to take leave for urgent family reasons, and your immediate presence must be required in terms of force majeure. So it can't be something that is planned. It has to be something that's very just an emergency at that time, and it has to be owing to an injury or illness of a close family member. So you can imagine it's a child, a partner, a spouse, a parent. And do we talk about then just also to say that in terms of entitlement for force majeure, you can generally, it's full paid and it's just paid by the employer. Sorry, Jennifer, I know you're moving on. Just finish really quick point. Entitlement to force majeure leave would be 3 days in a year or 5 days in 3 years.
Sorry, Laura, it skipped ahead on you there. I was eager to get to the baby slide.
Just love the baby names.
So thank you very much, everyone. That does bring the legislative side of our presentation to a close. And just something nice and light, we thought that we'd give to a nice little ending to the webinar, is that while we were on the Central Statistics Office, they actually just had this cute little poster in relation to the top Irish baby names for 2020. Obviously, there's been a baby boom in the last 2 years. So we just thought that it was nice to see what kind of names are still popular at the moment. But that's going to bring us on to the Bright Contract software itself. So each of the family leave that we discussed in today's webinar, they are in our company handbook, and I'm just going to quickly show you previews of it in our software. So we have here, this is our maternity section. We have our adoptive leave, paternity leave, parental leave, and finally parents leave. And these are all found in the company handbook section of Bright Contracts.
And just also to say there, Jennifer, they are always maintained and kept up to date. So, for example, those changes to adoptive leave and who's entitled to it, we've put those changes through. So it's continuous. You don't need to worry about when did that change happen and how do I need to change my policies. We'll do it for you with the Bright Contract software.
Exactly. And then just to say, for anyone who doesn't have Bright Contracts, if you're interested in seeing a demo of the software, how it works, what the content is, you can register for a demo in the follow-up email, but we also have a little survey at the end of the webinar when you all exit, that if you'd like to sign up for one, just simply answer yes, and I'll be in touch with you as well in relation to that. But you can also download the software and use it in trial mode as well, so you'll be able to see those policies for yourself in the handbook as well.
Absolutely.
And sorry, Laura, I just wanted to mention our next webinar. So we do have another webinar, which will be our last one for the year. So this will be in December, so the 2nd of December. And this is where we'll be taking a look back at all of the changes in employment law over the past year. Obviously, COVID has had a huge effect on our business and has made us all have to bring in new policies, whether it's hybrid working policies or obviously it gave rise to changes to family leave and things like that. So we just wanted to kind of do a year in review. So if you'd like to sign up for the webinar, the sign up details are in the follow up email. But again, in the survey at the end, as you're all exiting, there's the option to register your interest for that, and I can sign you up for it that way as well.
Perfect. So it's now time for the question and answers, part which I always find most interesting. If you have any questions, please type them in and we'll try and get to them. But just bear with us now for a moment whilst we bring up the questions. Just one that I see coming in here. I'll go first, Jennifer. That's all right. Can an employee be made redundant while on maternity leave? So generally, no, I would say they cannot be made redundant. As we've mentioned, it's a protective leave. They can be made redundant when they return to work, but when they're on maternity leave, we would advise against it. And when they do return, you need to be sure that you're following proper procedures and your fair selection as well, and that there's no way any form of discrimination in place.
Laura, I'm just going to go on to this question here. So what is the parental leave entitlement of a part-time worker? So here, entitlement to parental leave will be reduced, so it'll be on a pro rata basis. So if they work part-time, their entitlement to parental leave will remain at 26 working weeks, whatever length their working week may be. So this means that if they work 50% of a normal working week, the actual number of days parental leave granted will be 13 full working weeks. So I hope that makes sense and that's clear. But basically it would be on a pro rata basis.
Can an employee ask for additional paternity leave? Well, certainly you can always ask, I suppose. There's no statutory entitlement to anything beyond the 2 weeks. Whether an employer wishes to offer more or give more, that is their own prerogative, I suppose. The only thing I would say is if you're offering more, you just want to be sure that no custom and practice builds up, or if a custom and practice does build up, that you're happy to kind of have that for other people. So it would be something that you would think about carefully.
Just an excellent question that has come through there is, we have an employee who's about to have a baby through surrogacy. What would their entitlements be? Now, unfortunately, with surrogacy, there is no Irish legislation to cover the legal issues arising from surrogacy at present. Therefore, we don't actually have extensive information on this topic. But in the absence of legal legislation, what information is provided to us is that the legal status and rights of everyone involved in surrogacy is governed by the legislation dealing with non-surrogate births and children. But there is actually a proposal for an assisted human reproduction bill, which is to regulate many aspects of surrogacy. And this has been in existence since 2017. And the proposal, it covers things such as like the minimum requirements to be a surrogate, the legal status of everyone involved, and the regulation of any financial aspect of the surrogacy arrangement. And it has been drafted, but the bill, it still hasn't been made law, unfortunately, and there is no timeline at present in relation to any possible advancement with it, which is a shame, given the fact that surrogacy is becoming an ever important topic at the moment. It is a shame that the Irish legal system doesn't have anything around this. So our best advice really in relation to that would be to seek legal advice around those kind of arrangements, because there's such an absence of legal legislation, unfortunately. But hopefully as time goes on, and I'm sure people see themselves across social media, there's more talk about surrogacy, which is amazing to see. So hopefully that will kind of spark a bit more traction about the subject, and we can hopefully have some legislative guidance around this, hopefully next year or certainly in the coming years.
Perfect. Thanks, Jennifer. Just one that's come in there. If a baby is born 4 weeks premature, is the woman entitled to 4 weeks premature benefit plus 26 weeks maternity leave, or is it capped at 2 weeks? Just to go back then to what Jennifer was saying earlier, the amount of the extended leave in the case of premature births is equivalent. It's the same period. It's equivalent to the duration of the premature birth. So if the baby was 4 weeks early, 4 weeks premature, it will be 4 weeks. I know Jennifer used 2 weeks in her example, but it's not capped at 2 weeks. It's capped at the duration of the premature birth. So if it's 4 weeks, if the baby is 4 weeks early, it'll be 4 weeks plus the 26 weeks.
And just a question there about parental leave. So can the employer refuse an application for parental leave? Now, a refusal can only happen if the employee isn't entitled to take it, but the employer can postpone parental leave for up to 6 months, but they need to do this before a document confirming parental leave is signed. And so just to make that point ever present there. So it can be postponed, but it needs to be done before any documentation is signed.
Perfect. And then coming to a close, I think, but there's just one here. If someone is on parental leave, okay, sorry, I'm just having to double check myself which is the parental. There's so many P's. If someone's on parental leave, do you need to record anything on the pay slip or just put it through as a zero pay? If it's unpaid, there's no requirement to put it on the payslip because there's no allowance for that as such with paternity or maternity. We can put that on the payslip, so you could put it through as a zero payslip, but just keep your records elsewhere. So if you're using Connect, that you have it registered on Connect, or if you're just wherever you are recording that they've taken parental leave, you must have that recorded, but you don't necessarily have to put something on the payslip because there's no payment at all, so it could be a zero.
Thanks, Laura. Now, there is some other questions there, but they would kind of require a bit more extensive answers and further information. So we'll be getting back to those people via email in relation to their questions there. So that brings our webinar to a close. If you do have any other questions, you can feel free to email us at support@brightcontracts.ie, or our phone number is available there as well. As I said, if you'd like to sign up for a demo or to sign up for our next webinar, just pop your interest into the survey that will pop up on your screens at the end. But thank you so much to everyone for attending, and we really appreciate your interaction with our polls. We hope you enjoyed them, and we hope to see you all again at our future webinars. Thank you so much.
Thank you very much. Bye now.